My lady, my lords, I will, as I indicated before the short adjournment, now move on to the textual analysis of the problem before the court. The first point is something that's worth repeating. The focus has to be on the word replacement in the first sentence of the definition at page 295 in Rule 53. Yes, the trustees may adopt an index, but they may only adopt a replacement. So the question is, what does the power of adoption relate to? And in construing the word replacement, obviously one starts, or I will start, with the natural and ordinary meaning of that word in the particular context of the definition. But as the court knows, the expression replacement and its cognate replaced is used in the second sentence and in the definition in the appendix of in line with RPI. And the usual presumption, by no means irrebuttable, is that where the same word is used in different parts of a single document, it is used in the same sense. So those other usages of that expression are valuable clues to the meaning of the word replacement in that sentence. I would add at this stage that in one sense, Mr. Green assists my case on this point, because as he pointed out, there is a very strong link between the definition of retail prices index in the rules and the definition of in line with RPI in the appendix for two reasons. The first is the one he mentioned, that the phrase in line with the retail prices index or the RPI is an expression that is actually only utilised in the appendix. As Mr. Green put it, I think he said that the second sentence was merely signposting what was to come in the appendix. But that is a reason for drawing inspiration, as it were, in the definition in the rules from whatever meaning it may have in the appendix. The other more minor indication, which I think Mr. Green didn't mention, but I added by way of footnote, in the definition at page 295 of retail prices index, you will see the phrase without prejudicing approval, capital A. In fact, approval with a capital A is a defined expression only in the appendix. Now, nobody knows why that phrase was used. The corresponding phrase in the rules is tax approval, which you will see at the top of the next page, 296. Now,
can I just ask you this? Mr. Green approaches this on the footing that your submission necessarily means that replacement involves discontinuance of the former index. Do you accept that?
yes.
What is the position if nominally the index has not been discontinued, but its contents or the principles underlying its construction have changed so significantly that it no longer sensibly serves the purpose of its inclusion in the scheme? That isn't a discontinuance, or perhaps you think it is.
No.
Is there any escape from it in that situation under this scheme?
I have two answers to your Lordship's point. One is an answer.
It's a genuine question.
Yes, I have an answer to that.
It's a question rather than a point, would you say?
I'm sorry. I have an answer to the question, and I also have, if I may, an answer to what may be behind the question. The answer to your question is that certainly on our construction, there would not be a discontinuance and hence a replacement. So merely on the basis of the definition of retail prices index, the trustees would be stuck, as it were, with the original index. But of course, that would mean there would have to be an amendment of the scheme under the Rule 46 amendment power, which of course requires the employer's consent, but one would have thought that in the situation your lordship's envisaging, that wouldn't be a problem. I don't want to at this stage, get embroiled with the issues on the cross appeal, which of course raised issues about whether one can replace an index by amendment for periods of past service. That would be an issue, but I accept that on our construction, the only way of changing the index in those circumstances would be by way of an amendment. If I may just add this, which may go to the point why your lordship asked the question, it is obviously relevant to the question, to the issue raised by the Chancellor in his judgment. Well, surely it's sensible to read this as incorporating a flexible definition for that very reason. If the retail prices index becomes unsuitable, then you can change it. And our answer to that is, well, there is no inherent merit in flexibility. It depends on whether in 1991, which of course is the relevant timescale, it would have appeared to be, flexibility would have appeared to be a desirable objective. Now, of course, one answer to that point may be Lord Sumption's point from earlier on that the rules of an occupational scheme are a long-term document and draftsmen are always looking ahead at possibilities that may or may not be more or less remote. But it is the case, and it's our answer to much of the criticism made about inflexibility, that in 1991 there were none of the concerns about the retail prices index that have emerged in recent years. And you will have seen Lord Justice Lewison charts the progress of that debate, which really started in 2010. And that's why all the litigation to do with RPI versus other indices dates from after 2010, when the government decided to change the index. So yes, of course, a very far-sighted draftsman might have thought, well, maybe we can introduce that power, but there would have been in 1991 no need for that appreciated by pension practitioners generally. There we are. I hope that's an answer to your question anyway. If I may, just focusing on the critical words in the definition, prima facie in the submission, replacement and adoption are a two-stage process, or they are two different acts, and importantly, they occur in that order. Replacement followed by adoption. Mr. Green, of course, says that no, there aren't two stages, there is a single stage, and the adoption is the act of replacement. His construction also involves, it should be noted, a reversal of the word order. He says replacement adopted by the trustees means an index adopted by the trustees as a replacement. Also, we would say, as we do in our printed case, that Mr. Green's approach to that phrase does not really attribute any real meaning to the word replacement in addition to the word adoption. Now, when he was making his submissions, I had to check with my junior that I wrote this down correctly, but when he was making his submissions about the first sentence of the definition, he actually said, well, there are two limbs to the definition. The first is the General Index of Retail Prices published by the Department of Employment, and then they're separated, the two limbs are separated by or, and then it's any alternative adopted by the trustees. Now, of course, if anything, that points up elegantly the difficulty of his position, because he is not really contending for the index to be a replacement, he is contending for it to be an alternative, which is not the word that is used in the rules. On a related point, would you please turn in the bundle to page 48? Well, that's the electronic bundle. It's tab 3 of the core volume, if you've got it in hard copy.
What, the order?
I'm sorry? Page 48.
48 or 428?
Sorry, 48.
48.
48.
Yes.
Tab 3. This actually is the response, the grounds of objection filed by Barnardo's to the cross appeal. But the reason I want you to look at it is paragraph 5, because it's the only, I think, clear statement in written form of what Barnardo's say the effect of their construction of the definition is. Paragraph 5 says, the Court of Appeal's short and simple answer to the member respondents, and that relates to the cross appeal, is that if Barnardo's is right on the construction of the relevant rules, the trustees have, as regards pension increases to be conferred in any given future year, a power of selection between 1, RPI as published by the D of E, and 2, any replacement adopted by them without prejudicing approval. Now, what that clearly indicates, and Mr. Green's submissions this morning are completely consistent with this, is that on their case, the trustees could switch back and forth between the RPI and any other index, including the CPI, each April. There is no, in other words, there is no real sense in which, on their construction, the RPI which continues to exist is being replaced. It is simply being treated as one item on a more extensive menu for the trustees to select from each April. There is another point which I raise because it's not entirely clear to me from either the Barnardo's printed case or Mr. Green's submissions. It's this. Clearly, his case is that the word replacement, coupled with adopted by the trustees, extends to selection by the trustees in the way that I have outlined. But what's not clear is whether, on his construction, replacement includes official replacement, which obviously is at least a theoretical possibility. Now, if his answer to that is no, the word replacement is entirely governed by, adopted by the trustees, and has no wider meaning, that is not only very odd, because obviously official replacement is a possibility, but it becomes extremely hard to maintain if, as he has got close to conceding, although not quite conceded, that the word replacement in the appendix is a reference to an official replacement. In his printed case, he plainly advances the view that the Chancellor was wrong to take the view that replacement in the appendix meant official replacement, but he seemed to me at least to backtrack quite a lot from that this morning and said, well, it may be right, it may be wrong. And the obvious reason that he has sensibly backtracked is that he can't get away from the fact that the phrase adopted by the trustees does not appear in the appendix definition. So if it is the case that replacement in the appendix means official replacement, it would be very strange if the corresponding word in the definition we are concerned with did not at least include official replacement. And if it is accepted that it must at least include that, a lot of the objections made on the grounds of absurdity or uncommerciality are blunted at the very least, because on Barnardo's own construction, if replacement could involve official replacement, there would, on Mr. Green's arguments, be no real role for trustee adoption or for approval to be prejudiced in those circumstances. I raise that as an unclear aspect of their submissions. There's just one more point on the natural and ordinary meaning of the phrase in the definition. Mr. Green got his retaliation in first on this. It's the reliance on what Lord Hoffman said in Chartbrook. I won't take you to it because you're no doubt familiar with it, and the relevant passage is set out in our printed case. What Lord Hoffman said is that you don't just ignore the fact that the defined term is retail prices index. And these, particularly in a document where language choices are made deliberately or should be assumed to be made deliberately, that defined term itself will represent a distillation of the concept that is being expanded upon in the broader definition. So in our submission, it is of some significance that the phrase is retail prices index and not just index. And of course, the same point can be made about the phrase in line with RPI in the appendix. They are both focused on the retail prices index. If you ask, what is a distillation of the concept for which the appellant contends, it is any index which the trustees decide to select each year, subject, of course, to revenue approval. Retail prices index is not a distillation of that concept. Now, of course, I'm not suggesting it's a game changer or a decisive point, but we are, if I may put it that way, amassing textual clues as to what this definition means, and that is another such clue. So now one logically broadens one's horizons a bit beyond the definition itself, or rather the first sentence of the definition, to see what help one gets from the language of the rest of the rules. And here, of course, we come to the second sentence of the definition and the definition in the appendix. Now, I need only say this very briefly because you will have seen it in our case and it's obvious. We say that these provisions strongly support the members' construction. As I have said, there is a close connection between the definition on page 295 and the definition in the appendix for the reasons I have mentioned. The usual working assumption would be that the word replacement in the first sentence of the definition and the cognate expression replaced in the last line of the definition have the same meaning, as do those words in their corresponding positions in the appendix. And critically, we know from the appendix that the word replacement is given a meaning independent of any process of trustee adoption, because those words are missing. And just to emphasise the point clearly, the Court of Appeal unanimously took that view, and with respect, not surprisingly. Then we have the word rebased, which it's common ground that rebased can only mean by the official publishing body. And again, we would say normal syntax would suggest that in the phrase replaced or rebased, it is the same actor or entity which is involved in those two processes. Neither of the alternative approaches to construing the rules as a whole, by which I mean the passages that I've now looked at, really holds water. If one goes down the route Mr. Green adopts in his printed case, namely that replacement means the same in both the rules definition and the appendix, it cannot mean what he contends it means, because he cannot get round the fact that replacement is not juxtaposed with the words adopted by the trustees in the appendix, which is why the only apparently sensible alternative is the course taken by the Chancellor in his judgment, where he says, well, you have to give different meanings to the word replacement in the appendix and in the rules. Now, the problem with that, which the Chancellor himself recognised in paragraph 79 of the judgment, was that you end up with a potential conflict between the inland revenue limits provision and the scale benefit in the scheme. Now, Mr. Green spent a lot of time dealing with what he called the congruence point. And he says, really, it's not a problem that there may be different indices used for the purposes of establishing maximum benefits for revenue purposes and the scale benefits under the scheme. I want to deal with that now, if I may. At the abstract level, he's perfectly right. There is no necessary congruence between the two. And in a sense, that's obvious because the revenue provide a limit above which scheme benefits cannot be paid. And in the industry, if I can use a jargon expression, one talks about headroom between the scale benefits in the scheme and the revenue limits, which are the overriding limit for tax purposes under the old system, pre-2006. So, of course, it's right for Mr. Green to say that there might be circumstances in which the scale benefit is sufficiently below the revenue limit because of differences in definition between pensionable earnings in the scheme and final remuneration for the purposes of the revenue limits, so that one can shoehorn, as it were, in a better increased benefit than the one that appears in paragraph 6 of the appendix. Now that's all very well in theory. There are two major problems with it. Of course, the first is that there may be no difference in practice between the calculation of the scale benefit and the revenue limit. Mr. Green referred to the fact that the definition of pensionable earnings in the scheme is quite narrow because it excluded fluctuating emoluments. But if one has employees who do not earn fluctuating emoluments, and I don't know whether Barnardo's employees do, but maybe some cause for doubt over that, then there isn't going to be a difference. But the overriding point here is not one of technicalities. It's simply that it's not sensible to have a scheme where the scale benefits and the revenue limits are operating by reference to different indices. Because as the Chancellor rightly pointed out in paragraph 79, there is a risk of conflict. And it's all very well to say, as Mr. Green does, well, Rule 32 then pops up and says, well, there is a requirement on the trustees to reduce benefits so that they do not exceed revenue limits. But first of all, somebody's got to realise that they have exceeded revenue limits, and it requires the benefits of every member to be checked to make sure that there is no breach of the limits by reference to this disparity between the two indices. The simple practical point is this, and surely this is the important point. If you have mandatory pension increases in accordance with the prescribed rate, that is RPI capped at 5%, there is no possible danger of breaching revenue limits where the revenue limits are calculated by reference to the same index. Because obviously, RPI capped at 5% must be equal to or less than RPI. Now, with respect, this is an ingenious but ultimately hopelessly impractical suggestion that a scheme is going to embark on paying benefits where there is a mismatch between the two indices. One other point that Mr. Green made in relation to this, he referred you to paragraph 10 of the appendix. That's at page 299. And he referred to the second sentence of paragraph 10. The benefits may exceed the limits set out above with the prior consent of the Board of Inland Revenue. Well, with respect, I'm not sure where that takes him, because whether in relation to a particular scheme there has been an agreement with the Board of Inland Revenue that benefits may exceed the limits is obviously a question of fact. And either there has been or there hasn't been. I don't know if there has been in this case, there's no evidence about it. But it doesn't tell you anything about the meaning of the word replacement.
Well, the limits that are to be exceeded are limits which include the phrase in line with the RPI. Therefore, that sentence cannot alter the meaning of the limits which can be replaced.
Exactly.
So, I mean, it tells us nothing.
It tells you nothing. Yeah. So, my lady, my lords, that's all I want to say about the language. If I may, I'll now move on to what I call the contextual issues, and principally Mr. Green's reliance on IR 12. In the course of explaining what IR 12's significance is and the background to it, Mr. Green didn't really address what we see as the fundamental problems for him in relying on that document as a guide to construction. And there are two principal problems. In effect, his argument piggybacks on some of the earlier first instance decisions that my Lord Hodge referred to, where the judge said, yes, well, I can see from the wording of the definition that the draftsman was probably trying to take advantage of the easement, if that's the right phrase, the flexibility in IR 12. But of course, the point is these arguments all depend on the wording of the particular rule. And in the earlier first instance decisions, the wording was not that dissimilar from IR 12. IR 12 does not use the expression replacement anywhere. Certainly not in the footnote to paragraph 6.14, which Mr. Green took you to. So that document can give you no guidance on what the word replacement means. More importantly, perhaps, is this. IR 12 is about revenue limits. The one place, if Mr. Green is right, that you would expect to find the phrase adopted by the trustees is in the definition in the appendix, because that is dealing with revenue limits. But of course, it's not there. The third point, which we deal with in our written case but ought to be emphasised, is that the appellant's written argument refers to the definition as, quotes, hardwiring into the scheme a condition of discretionary approval. Now, one could perhaps see the force of the argument if there was a requirement to obtain, to secure revenue approval, that the rules are in a particular form and contain a particular provision, then one might conclude, yes, well, clearly that's what the draftsman was intending to do. And indeed, that was the sort of case that was being dealt with by Lord Hoffman in the National Grid case that Mr. Green relies on in his written argument. But that is not the case here. There is no condition or requirement of discretionary approval that a flexible definition of retail prices index be incorporated. Whether he's right or I'm right about the meaning of the definition, it doesn't matter a jot to whether the revenue would have granted, as they did, discretionary approval. Or indeed, if the definition, if the rule had simply said, prescribed rate is retail prices index limited to 5%, there would have been no problem so far as discretionary approval is concerned. That was also a point on which the Court of Appeal were unanimous. The Chancellor agreed with that point too. So we say for those reasons that actually IR12 doesn't help, or to put it the way that Lord Justice Lewison did, correctly, we would submit, reliance on IR12 just begs the question. Yes, it is possible within the confines of IR12 to have a flexible definition, but that doesn't tell you whether the draftsman and the parties in this case chose to do that. To reach a view on that, you have to construe the word replacement. I would, having said what I have about IR12, I would, if I may, add a few words that reflect my submissions before the short adjournment and come back to what Lord Briggs said in Safeway and Newton, because there is a not unimportant policy point here. IR12, the practice notes, are not incorporated by reference into these rules. There is not a single reference to IR12. It is, IR12 itself is a technical document whose target audience is employers and their advisors. And one sees that. If you wouldn't mind turning to tab 1 of the authorities, that's page 311 in the electronic bundle. And it's paragraph 5 of the foreword on the first page. These notes give guidance only in general terms as to the manner in which the Board of Inland Revenue exercises its discretion. And the board may find in particular cases circumstances justifying different treatment. It's always open to employers and their advisors to approach the SFO to discuss what can be done in a particular instance. Now, of course, trustees, at least these days, are likely to have either a secretariat provided by the employer or its own legal advisors who will be familiar with IR12. But with respect, what about the average member of an occupational pension scheme? Over the weekend, I tried Googling IR12, and yes, you can get it online. It's in the government's online National Archive. But you have to know what you're looking for. And in the real world, how likely is it that any member of an occupational pension scheme will even have heard of IR12? A fortiori, the pension scheme's office manual, referred to by the Chancellor and referred to in the appellant's written case, although not orally this morning, which is a guide prepared for Inland Revenue staff. There is, I would respectfully suggest, an air of unreality about a suggestion that IR12 forms part of a factual matrix known or accessible to the members of the scheme if, as I suggest is the case, their interests need to be taken into account given the nature of the Occupational Pension Scheme Trust. I make these observations and submissions because it has become rather common practice in pensions cases at first instance for revenue materials, particularly IR12, to be pored over whenever a construction issue arises. Now, that practice has developed from very sensible but much more limited statements in earlier cases along the lines of, well, of course, a fact the court must take into account is the need for revenue approval and the requirement that the rules will satisfy certain revenue requirements. And if approval under the former regime is on the line, as it were, if it's a particular point arises that does go to approval, one can see that would have to be addressed by reference to the revenue materials, even if one has to put concerns about accessibility on one side. But beyond those cases, I would respectfully submit that courts should be cautious. It's not inadmissible, but should be cautious about giving weight to technical documents such as these as part of the relevant background. My last reference to Lord Briggs in Safeway, he said in the passage we've quoted that the occupational pension scheme context is antipathetic to the recognition, amongst other things, of a common dictionary between the employer and the trustees. And we're all familiar with commercial dictionary cases, as it were, where the parties have used a particular word to mean something that it wouldn't normally mean. What, in effect, the appellant is doing in this case is asking the court to adopt a meaning of the word replacement derived supposedly from just such a dictionary, namely IR12, known to the actual parties, but in all probability not to the members. And I have to add this, moreover, the word replacement isn't even in the dictionary. My lady, the last, I believe it's the last thing I have to do is to deal with the commercial common sense and absurdity arguments that are canvassed in Mr. Green's grounds 2 and 5 in his printed case and elaborated upon this morning. What I'm going to do is only deal with the ones he dealt with orally, if I may, because either he's not too bothered about the others, or in any event, you have our response in writing. And I don't want to take up unnecessary time. The first of those points is that in 1988, perhaps one should say 1991, it was a very improbable scenario that the RPI would be officially replaced. The way he put it this morning was that it's almost impossible to get rid of the RPI. Therefore, that possibility would not have been at the forefront of the parties' minds when these rules were made. Well, there are several answers to that point. The first is that, as a matter of fact, as Lord Justice Lewison sets out in paragraph 15 of the Court of Appeal judgment, the government's headline inflation index had in fact been replaced in just that sort of manner on 2 previous occasions, 1947 and 1956. So the official replacement of such an index was not in itself an unlikely scenario. Second point, it doesn't matter whether that possibility would have been at the forefront of the parties' minds for the very reasons given by Lord Sumption this morning. pension scheme documents are intended to be long-term. All draftsmen are cautious, and the better they are, probably the more cautious they are. Their job is to envisage things that are not at the forefront of the parties' minds and to deal with them preemptively. Therefore, it doesn't matter whether the parties themselves would have envisaged this at the time. But the other real problem with the argument is this, and I'm just going to show you one passage in the previous rules of the scheme. You will have seen in our printed case that we take issue with the proposition that you can derive anything useful in terms of the construction of a particular phrase by comparing it with what was said in the previous set of rules. And that approach appealed to the Chancellor, and in my view, quite rightly, the appellant has not pursued that point. I am not seeking to do that. All I am seeking to show you is that the supposedly improbable scenario was exactly the scenario that was dealt with in the 1978 rules. You'll find that at page 176. It's tab 6 of the appendix.
Sorry, could you give me the page reference again?
Sorry, 176.
Thank you.
Now, these are referred to as the 1978 rules because that is the date to which they were retrospectively effective, but the deed is actually dated June 1984. You see that at the top of page 166. So in 1984, the corresponding definition, which is very differently worded, at the top of page 176 is index, shall mean the government's index of retail prices or any other official cost of living index published by authority in place of or in substitution for that index. And its common ground has been, since first instance in this case, that is dealing with what we have called official replacement only of the RPI. Now, I draw no succour from it on the main point, but it does show that the parties, via the draftsman, in 1984, were contemplating the official replacement of the RPI as at least a possibility. Now, the second set of points relate to what is really, I think, a joint objection that our construction of the word replacement effectively denudes the trustees' power of adoption of any real scope. And I think related to that, they say that the words without prejudicing approval in the definition can't have any real scope where it's an official replacement because it's obvious, isn't it, that an official replacement would be would satisfy the inland revenue. The second point, of course, is exploded if you accept the submission that replacement in at least the appendix means official replacement, because the appendix also provides for replacement of that index, not prejudicing approval. So whether theoretically this is, Mr. Green is right to say that surely the requirement for not to prejudice approval is a statement of the obvious, whatever the merits of that, it would be a point that could be applied to the wording of the appendix, and if you're satisfied that replacement in the appendix means official replacement, it really doesn't take one very much further. But the fact is that all the, well, not all the judges except the Chancellor accepted that it was a real possibility that the retail prices index might be replaced by a number of different variants for different purposes. Mr. Green himself referred this morning to one variant, RPI-X, excluding mortgage interest. It is quite possible that one or more of the variants would not be considered by the revenue to be suitable for the specific purpose of indexing the purchasing power of pensions. And this sort of point does create difficulty, I mean, for this court, because one has Mr. Justice Warren, one of the most experienced judges at first instance dealing with pensions matters, who says at, I'll just give you the references, paragraphs 55, 65 and 67 of his judgment, that he doesn't think it's improbable or fanciful that there may be multiple replacements, some one or more of which may not meet revenue approval. Lord Justice Lewison saying the same thing, and Lord Justice McFarlane adopting what he said. And then on the other side, the Chancellor says, well, I don't think that's very likely. How is this court meant to reach a decision in relation to a point like that? It's invidious. And in my submission...
Is that the sort of point that one makes or decides by reference to who has made the same point previously? Doesn't one try and think it through for oneself?
One would. But it is a speculative exercise in its nature, and my submission would be that it emphasises the importance of relying on textual matters where we know what we are dealing with. I accept, to pick up one point that Mr. Green made, that if indeed there is only one replacement index, then the trustees would have to adopt it in practical terms. Clearly, there isn't a choice because there is only one replacement. But that doesn't make the definition unworkable.
Well, in a way, he says that your approach denudes adopt of meaning, and you say that his approach denudes replacement of meaning.
Yes, I wouldn't disagree with that.
That seems to sum it up, really, doesn't it?
Well, yes, obviously we say there's a bit more to it.
Of course you do. Of course you do. There always is.
And you've heard nearly everything I need to say on that. The last 2 points. The appellants rely on what the Chancellor said in paragraph 90 about there being business common sense even in 1988 to having a flexible index. And this is the point I was raising with Lord Sumption when he asked me the question shortly after 2 o'clock. Lord Justice McFarlane's response to that same point was, well, where's the evidence that that the possible unsuitability of RPI in the early 1990s was even potentially a matter of concern? And there is no such evidence for the reasons I have mentioned. It is very easy, as the Chancellor himself said, and said was not appropriate, to look at business common sense through present-day spectacles without sort of realising that you're doing it. And we would suggest that the plea for flexibility really does that. The last point is something that Mr. Green, I have to say, spent much longer dealing with than I expected him to, which was our point about balance of power. If you look at paragraph 30, subparagraph 2 of our printed case where we deal with this, we do say that it only modestly supports the members. This is not a make or break point. And the only point we make about it, I can sum up in this way. The broader the discretion that is conferred on the trustees to replace index, the greater is the scope for liabilities to be imposed on the employer, which it is not expecting and has no control over. So the simple point we make is that the absence of an employer veto is more consistent with a narrow discretion than it is with the much broader discretion that Mr. Green contends for. My lady, that's all I was going to say, unless, of course, any member of the court has questions.
One question. Do you want to add to or contradict anything Mr. Green said about the provenance of the appendix?
I can't add anything to it because, like him, I don't know.
Okay.
I am perfectly prepared to accept that it is likely to be a bespoke in-house precedent. I have no reason to believe otherwise.
Okay. Thank you.
And I think probably that's the answer that I would want to give anyway. But I absolutely don't know, and I'm perfectly prepared to accept what he says on that.
Thank you very much indeed. Thank you. Mr. Campbell? Thank you. Mr. Stallworthy?
My lady, my lords, having heard the competing arguments on both sides, the trustees have no submissions that they would wish to volunteer, but if there are any points that the court would like to hear from the trustee on, we're very happy to assist in any way we can.
Well, you're possibly the only people who might know the answer to the question that has just been asked.
Well, I confess I don't know the answer to that question, but I would certainly agree with both of my learned friends that it is commonplace to see firms of solicitors with their own standard in-house appendix, which is bolted on at the end of sets of rules that they draft. My learned friend, Mr. Green, I referred to the fact that there was at one point a standard inland revenue model rules document, which was publicised and made available and sometimes used. My recollection is that this document does not reflect the model rules, so it does appear to be a bespoke solicitor's summary.
Thank you.
Thank you. It appears there are no further questions of the
I'm
trustees.
ready.
Thank you, Mr. Stallworthy. Mr. Green?
My lady, I'm grateful. Can I just pick up in the first instance the discussion about principles of construction in this case? I don't want to follow this too far because we say that there's normal and ordinary principles of construction apply. There's nothing special about this case. But I just want to express almost personal interest in relation to this point that it's the reasonable member's understanding which should actually inform your view in this matter. I do appreciate naturally that there is a certain current. It's not necessarily running very strongly or on a fully reasoned basis, but there's a certain current in judgments which shows a sympathy to taking into account what would have been apparent to the reasonable member in this context. But I do wonder to what extent that is actually right. Naturally, one is sympathetic to the need for a member to understand the rules, but of course the rules are a complicated document. But after all, at the end of the day, the deed and rules are produced by the employer and the trustees. They are a bipartite document, and they confer rights on third parties. But the reasonable understanding of those third parties should not determine the quality of those rights. The quality of those rights, if it derives from anything, should derive from the reasonable understanding of the parties to the instrument which conferred those rights. And if one's going to start getting sentimental about the rules of pension schemes, where does the sentimentality stop? Does it include every trustee? Does it include every case where the Contracts Rights of Third Parties Act has actually suspended the operation of the doctrine of privity, so that everyone within the province of a particular contract, one has to consider what they would have reasonably understood? I simply raise that with you. I don't think that the result in this case, with the greatest of respect, turns on the limits of the construction principles derived from a sentimental consideration of the interests of members, important as the interests of members are. The next thing I want to take up, if I may, was the point which my Lord Sumption raised with my friend Mr. Simmons just after the short adjournment. He said, as we all know, well, just hold on a minute. So is your case then that if there hasn't been an official replacement of the RPI, but the RPI has become inappropriate, that the trustees are stuck with it? They cannot, in those circumstances, adopt a replacement of RPI. They simply have to live with the inappropriate index.
Escape route was Article 46.
Yes, but of course that doesn't work, because quite independent of Section 67, there is a proviso to Rule 46, which would prevent the amendment power being exercised so as to entrench on past service rights. If we look at page 284, manuscript page 284, you see it's not a point, it's not so straightforward a point for him. It's not a point which can be shuffled off to the cross appeal. It's a point which that there is an obstruction to the company and the trustees dealing with such a situation in the form of Proviso A. No alteration or addition shall prejudice or affect any pension or annuity then payable under the scheme, or any benefit already secured at the effective date of the alteration. So the position is, on the member's submission before you, that no matter how inappropriate the index has become, there's absolutely nothing that can be done about it in relation to past service.
Proviso A is about pensions in payment.
And any benefit already secured. So it's about it's also about accrued rights. It's about benefits based on past service.
Yes.
So I'm afraid there is no escape from the fact that, notwithstanding the fact that it is common ground in this case, that the purpose of this provision is to ensure that you have an index in place which is appropriate to the purpose of providing inflation protection to members. If RPI becomes inappropriate, that purpose is frustrated. Now, the next point that my learned friend made was by reference to MS page 48, paragraph 5 of the objections that we put in relation to the cross appeal. And my learned friend drew attention to the language that we used. And he said, well, look, this basically sums it up. It says it all, that the way in which Barnardo see this case is one where what the first sentence of Rule 53 effectively provides for is a power of selection. You can have RPI one year, you can have CPI the next year, you can have RPIX the next year. You can pick and choose your index from year to year. You can dodge and weave freely. Look, just putting to one side for a moment the practicalities of that and recognising that trustees exercising fiduciary discretions are not going to essentially running this as a kind of gaming room where they switch from index from year to year with abandon. Well, an index, when it's appropriate, will be appropriate for a period, but the trustees should have the liberty to continue to consider whether it remains appropriate. Putting aside the unreality of the switching from year to year proposition, all we are saying to your lordships is that it's open to the trustees to replace RPI in any given year. And if it replaces RPI in that year, obviously the expectation would be that the replacement would be adopted in the following year and the year after that and the year after that, because frankly, that is coherent, joined up trust administration. But if the trustees decide against a backdrop of RPI continuing to exist, that, you know something, RPI has been looked at again because of all the criticism that it has received. And it has now become the appropriate index again. It has been adjusted by the UK statisticians. Then it's open to the trustees on our construction not to adopt a replacement in that year, in which case RPI holds the ground again. So if one's looking at the matter as a matter of construction, I don't want to occupy a world of fanciful examples of how the trustees might exercise their discretions. If you're looking at it as a matter of construction, so long as RPI continues to exist as a matter of construction, this is simply a matter of whether the trustees decide to replace RPI in a given year or not. And as I say, they're obviously going to have some degree of continuity in any decision-making process they make, because you've got to assume you're dealing with rational trustees rather than trustees who are being completely quixotic. Now, the next point that my own friend made was, he said, well, I'm not quite sure where Mr. Green goes on the question of whether the index has to be an official replacement. Well, I have to confess, and perhaps I didn't follow the point with sufficient attention, I wasn't sure where that particular potential criticism or criticism of Barnardo's submission was going. I had an exchange with my Lord Hodge this morning as to what the index might or might consist of, and also with my Lady Hale, the Any Old Index discussion. We recognise, as I thought I made clear this morning, that the candidate index is liable to be an official index, because that's the nature of the beast, the nature of the thing which one is concerned with. It need not be an official index, but we recognise that it's likely to be. It's as simple as that. And really, the points that I've picked up from my learned friend are essentially the points that he's made in response to the case that we've made as a matter of construction. We've already dealt with the Chartbrook point. I've got nothing to add in relation to that. We maintain the position that the use of the label Retail Prices Index does not answer the question in this case. It just merely tells you that you're dealing with the Prices Index. So far as regards the first sentence of Rule 53, there is not that much. I mean, it may be said that, we've said more than once it's a short point, there's not actually very much comeback. What happened after we got to this point in my learned friend submissions is we went straight off to the Inland Revenue Appendix. We went straight off to that which we, Barnardos, object to, being the basis of the construction of the first sentence in this case. We went straight off to the second sentence of Rule 53 in the Inland Revenue Appendix, and the tail wagging the dog. So far as regards that appendix and the congruence point, I'm very grateful to my learned friend for his agreement and acceptance that in abstract principle, what we said to you this morning was correct, that there does not have to be a match, that you shouldn't be dismayed by the absence of a match between what's contained in the Inland Revenue Appendix and what's contained in the rules of the scheme providing for the scale benefits. The fact of the matter is, as my old friend very helpfully elaborated this afternoon, it is routine to talk in terms of having headroom in terms of inland revenue limits. And what that means, as my friend very clearly explained, is that you do a cross-check between your benefits, your scale benefits under the rules, and your inland revenue limits, and you satisfy yourself, and it doesn't, frankly, in the vast majority of cases, take very long. You satisfy yourself that you've got no issue. And in the vast majority of schemes, you don't even need to do the cross-check because of this final pensionable earnings point. Final pensionable earnings are so much less generous than final remuneration that there's no issue. But yes, in any case where there is a concern as to whether you are going to hit the limits or not, of course you'd expect the benefits office of a particular employer to check whether you're going to hit the limits, because the last thing you want to do is to infringe them, thereby potentially aggravating your relationship with the revenue. And at the end of the day, the important point to remember is this. If you do break the limits, obviously if you do it deliberately and you do it persistently, you're going to aggravate the revenue. But if you do break the limits, at the end of the day, you scale back the benefits. That's all that happens. The world doesn't come crashing in. Commercial common sense. My learned friend relies on paragraph 15 of Lord Justice Lewison. And the point that he makes is to say, well, Barnardo's are wrong. They're over-egging the pudding in saying that in 1991, people would have imagined that there was that people would not have imagined that there was a practical possibility of RPI being replaced. He says, look at paragraph 15 of Lord Justice Lewison. Paragraph 15 of Lord Justice Lewison, and perhaps we might turn it up, please. Sorry, I don't have the MS number.
121.
Thank you so much. Thank you. It doesn't, with the greatest respect, tell you very much, but what it does tell you, if your lordships would, in relationship mind, just reading it, is that there were some relatively unsophisticated and primitive precursors to RPI, but that come 1956, the general index of retail prices, that which has now come to be known as the RPI, had been adopted. Now, in the first sentence of paragraph 16, Lord Justice Lewison, who did not have the benefit of the expert evidence that Mr. Justice Zaccaroli had in the BT case, says it's not entirely clear when the index of retail prices, that is the thing referred to in the first limb of the first sentence in our case, became the retail prices index. But all he's saying there, and I'll show you, like Mr. Justice Zaccaroli in a moment, all he's saying there is, well, I'm not entirely clear as to when its name when it, as a matter of currency, it ceased being called the General Index of Retail Prices and started being called the Retail Prices Index. It's perfectly clear that the Retail Prices Index, and certainly the General Index of Retail Prices, which is the thing which is referred to in the first sentence, dates from 1956. And if your lordships have any doubt about that, paragraph 105 of Mr. Justice Zaccaroli in BT, having heard lengthy evidence from Mr. Paul Johnson on behalf of the company and from a gentleman from the Royal Statistical Society on behalf of the members, states RPI was founded, was instigated, was created in 1956, and that is a fact. Now, the point here is that it endorses Barnardo's interpretation. It doesn't undermine it, because the fact is that for 35 years prior to the adoption of the 1991 rules, RPI existed. And so I repeat the point. With a 35-year history, it is inherently unlikely that those who were subscribing to the first sentence of Rule 53 were proceeding on the basis that it was going to be discontinued and cease to exist, apart from all the other commercial considerations which I've laboured this morning. And really, those references in paragraph 15 of Lord Justice Lewison do not take the matter any further. Now, of course, I accept the point. It was made to me this morning. It's obviously been taken up by a learned friend, that pension schemes are long-term entities, that they are cautious draftsmen. Good draftsmen are cautious draftsmen, to a point. They can be bad draftsmen. A cautious draftsman produces documents which are not terribly good. But Cautious draftsmen are to be applauded for being non-negligent. Yes, they're long-term documents, but let's not forget what the agreed purpose of this rule is. The purpose of this rule, year in, year out, is in order to ensure that appropriate pension increases are provided. And just because it's a long-term document doesn't mean to say that you subscribe to the long-term vision that RPI has to be annihilated before it can be replaced. It's got the long-term document point, with respect, doesn't go anywhere. So far as regards the previous rules, it's absolutely right. My learned friend says, your lordships will have seen, we don't rely on the previous rules. Why would we? They obviously were replaced by the 1991 rules. The 1991 rules say what they say. It's undoubtedly the case that the 1991 rules give Barnardo's an argument which they didn't have under the previous rules. So, the point with the greatest of respect, doesn't go anywhere. And finally, and I know your lordships have got this point, but I'll just make it in 30 seconds. My learned friend, perhaps unsurprisingly, to some extent, concertinaed our objection based on the use of the word adopted and our objection based on without prejudicing approval. We said in respect of both that it seemed unlikely that in the case of a replacement of RPI in circumstances where it had been discontinued, that the word adopted was an appropriate word if the trustees were not a more liberal discretion. And we said in relation to not prejudicing approval that it seemed a bit odd to give the trustees the policing role in relation to that. I did try to acknowledge, although it got slightly lost in the discussions between us, I did try to acknowledge this morning to my Lord Briggs that I accepted that on the more limited interpretation of paragraph 10 of the Inland Revenue Appendix, my second point on without prejudicing approval didn't have legs, really. I was in the process of accepting that, and my learned friend drew attention to that. But the point on adopted remains, as we would respectfully suggest, as strong as now in reply as it did when we made it this morning, and it cannot be regarded as infected by any weakness of the in relation to the point on without prejudicing approval. Unless I can assist you further, that's all I wanted to say in reply.
It looks as if you've been of sufficient assistance, Mr. Green. Thank you very much indeed. What we now propose to do, obviously, is to retire to consider where we are on the appeal. We will let you know. We won't be coming back into court today. We will let you know as soon as we can whether we require your attendance to argue the cross appeal tomorrow.